Hi, everyone. Good afternoon. My name is Whitney Derber. I'm a lawyer here in BC, and I work with Miss Susan Apperley.
Hi, that's me.
Also counsel here in BC. And today we're going to talk to you guys a bit about some of the issues you might face in trying to navigate disability benefits. So that would be long-term disability, WorkSafeBC benefits, and also CPP-Disability. I would note kind of at the very outset, because I know we'll probably get a lot of questions, we can't answer any questions that are specific to your unique circumstances. It's really important for us as counsel that we have a full set of information before we give specialized legal advice. Which would mean we'd need to look at the case file. We'd need to talk to you about your specific circumstances and look at the medical evidence. But we're happy to field any questions that are kind of generally about the process, about what kind of some terms might look like, about what an appeal might look like. And so I know we've got a lot to cover, so we're going to kind of try and dive right in. So I'm going to talk about long-term disability benefits, and then Susan's going to talk to you guys about WorkSafeBC and CPP-Disability. There we go. So first and foremost, applying for LTD. Sorry, just trying to move this. So the way that it works with LTD, some employers have short-term disability benefits. Sometimes it's a sick bank. Sometimes it's just short-term disability that's either through the employer directly or through a third party. But then you would essentially, if you're still disabled at the end of that time period, you would roll into a long-term disability plan. And usually that's bundled up by your employer in a benefits package that also includes extended health benefits. So when you've been disabled for the prescribed waiting period of time, and it depends on your policy, and we'll talk a little bit more about kind of the terms of a policy, but you need to go back to the policy to find out what is either called the waiting period or the qualifying period. And that's usually a period of 3 to 6 months of disability before you qualify for those long-term disability benefits. And when you've reached the end of that prescribed period of time, you would then submit an employee application, which you should be able to get from your employer. There may or may not be an employer portion. There often is, and just making sure that your employer is submitting that in a timely fashion. Providing your attending doctor with the physician portion, and that fee is payable by the person applying, and making sure that that is submitted in a timely fashion, and also any other essential medical documents or tests that support your disability. So if you feel like there are helpful tests or helpful assessments done by a specialist, you can also submit those in support of your LTD claim. What we have been seeing a lot of lately, and what's really important to do, is regardless of whether you think it's going to be denied, do it in the time that's set out in the policy. This is often within a 4 to 12-week window after the end of that waiting period or the end of your short-term disability. If it's beyond this period, it's really hard to contest. It must be shown that there are reasonable grounds for you not to have applied during this period. And oftentimes what that'll look like is an employer was wrong in kind of giving you information. There has to be really kind of a more severe period of disability that would have prevented you from completing things, but it's really a hard bar. And the application is usually relatively short. So if you can, just make sure you get it in. If it looks like you're hitting the end of that waiting period and you're still going to be on disability at the end of it, start getting the documentation ready in that prescribed period of waiting, so that you have it all ready to submit at the end of that time period. This is one of the ways in which you can lose access to those benefits, and you don't want to lose access to those benefits. Okay. So once you apply and the whole package is together, it goes to a case manager at the insurer, and that insurer then assesses you for eligibility in reviewing your disability and then also looking at your job demands, which is in part what the employer submission is for. That determination is usually made within 2 to 8 weeks. If your application is accepted, this will stop any payments that you have to make for LTD coverage. And it will also often stop any payments that you need to make to keep your extended health benefits with the same insurer. But that'll be set out in your policy if that's the case. I'm sure that many of you have experienced this, but unfortunately, those initial denials are quite common. And that's especially true when we're talking about conditions like what many of us here see Dr. Arsenault for, which would be fibromyalgia, chronic fatigue, POTS, EDS, all of those. So anything that is a little bit more subjective, which I don't really like that word, but where it's not a broken bone that you can objectively see on an X-ray, or something that's a little bit more visual in terms of imaging, it is more common there will be a denial. When we look at if you are denied for benefits, it's really important. What you're usually given by an employer is a policy booklet, and that policy booklet usually is more of a summary of the policy than the policy itself. And the policy itself will be between the employer and either it'll probably come through a broker, but it'll be between the employer and the insurance company. And so you want to get a copy of the full policy, because the rights to your disability benefits are essentially a right of contract. And that contract is the policy itself, and the terms are specifically important and they're unique to the policy. So what we're going to do in just a minute is kind of go through some of the common terms that we see arise under LTD policies that are important for you to know if you do either apply and you are accepted. It's still important to know these policy terms, but if you're denied as well, it's really important to understand them. And they vary from policy to policy, although there is a lot of commonality. And so let's just kind of jump right into some of those. So what I've done is I've also taken little snippets just to kind of give you an example of what they look like. This is a very, very old policy, as you can tell, because you'll see at some point it refers to Great West Life, which is now Canada Life. But just to give you an idea of what that kind of policy term is that we're talking about. So the first one is your effective date of coverage. So usually when you start with an employer, there'll be a period of time under which you are not covered, and then kind of the policy kicks in. It used to be very common for that time period to be about 3 months of ongoing employment. We've now seen policies that go up to a year, which is quite striking, but we've seen it a couple times now. So it's really important to understand at what point your effective date of coverage kicked in, and where you see that really kind of the interplay between the policy terms that's important for effective date of coverage is the interplay between effective date of coverage and pre-existing conditions. And the importance of that is if you had a condition, say in the year leading up to your employment with this employer, and you've seen some kind of reduction or resolution in your symptoms and you're able to re-engage in employment, and you end up, under this policy, you need to know when it kicks in. And then there's usually a period of time after the effective date of coverage that it continues to apply for pre-existing conditions. And we'll take a look at that again a little bit later in terms of what that looks like for pre-existing conditions. The next one is definition of disabled. And there's a couple different ways that this comes into play. The first of which is we've had this question a couple times, but there is a difference between a definition of disabled for your own occupation as well as any occupation. So usually it's a period of 2 years from your initial effective date of coverage when you start kicking in your claim. That 2-year period of time, they look at whether or not you are disabled from your job, whether you're disabled from what you were doing, even with modifications. And then if you continue to be disabled from your own position, then over time they start to look at, okay, are you able to do other types of employment? So after about 2 years, which is what we often see in terms of the shift from own to any occupation, after 2 years, they look at, okay, you can't do your own job, but could you do another job? And we'll look at this in a bit more detail, but it doesn't mean any occupation. It doesn't mean they're going to expect you to do something well outside of your skill set. The other thing is you don't have to be totally disabled to qualify for long-term disability. So every policy will have a threshold, and that threshold can be either in terms of a percentage of hours or a percentage of your income that you bring in. And the reason I've put 2 here is this is a very interesting policy in that it defines it in 2 different locations in 2 different ways. So you'll see in the one on the left that it defines gainful employment and whether or not you are gainfully employed and therefore not disabled as being earning at least 60% of your income. But when it talks about your disability, it's being assessed in terms of 60% of the work that it took you to complete previously. So it's important to look at a couple different things when you're looking at your policy. One, at what point does it kick from your own occupation to any occupation? And 2, how do they define disability? Is it 60% of what you do? Is it 50%? Understanding where that threshold is important to understand whether you initially qualify, because you could be able to work part-time and still qualify for long-term disability benefits. But it's also a threshold to keep in mind as you start to recover and thinking about when you might be kicked above that threshold. Next is the waiting period. So we kind of talked about this at the beginning, but that waiting period is the beginning period of disability where you don't qualify for long-term disability benefits, and then they start to kick in. So for this policy, it was 6 months, and you'll see that there are further qualifications, which essentially means it doesn't have to be continuous, but here are the specific requirements if it was not continuous, and you might see that in your policy as well. The next definition that is important to look at is insured earnings. If you have a basic hourly or annual salary, it's probably not that essential of a term for you. If you have a mixed set of income that also includes bonuses, that includes commission, it's important to look at what your insured earnings are. And it may be important to look not just at the policy itself, but what when you were kind of onboarded to the policy, what was submitted by your employer. You might also hear people refer to a COLA. What a COLA is a cost of living adjustment. Some policies have this and some don't. But essentially, it allows for a cost of living rise in the amount that the insurer pays you while you are on disability. It's usually calculated annually, and we'll look at what the cost of living has been for the year, the cost of living adjustment, essentially. Income offsets as a percentage of threshold. This is really important because oftentimes people are applying for more than one disability benefit. And so that would be true if you apply for an LTD benefit and CPP-Disability. Many policies will require you to apply for CPP-Disability, sometimes initially, and then sometimes if you've been on LTD for some time. So that's often a common one that is requested. And then there can be offset, and that can be different than when you're looking at the percentage of disability for when that threshold occurs. So in this policy, although the threshold of disability and income and what's payable is 60%, it's 85% for reduction benefits. So that could be whether it's retirement benefits, employment benefits. So if you're working part-time, they take that into consideration in calculating your benefits. So it's important to look at what other sources of income you have to report, and that could also affect what you receive from the benefit provider. Benefit determinations. Again, it's important to look at the terms to look at what percentage of your income is allowable, whether it's gross or net, and what this is determined essentially as to whether or not your benefit is taxable is generally determined by who paid for the policy. So if you paid for your LTD policy, it is usually not taxable, and confirm this advice with an accountant. But usually if you've paid for the plan yourself, it is net. But if your insurer paid for the LTD policy, it will be gross. And so it's important to know that. Now, if it is net, they still calculate what your after-tax amount would have been, but it just means it goes a bit further, and what you receive is non-taxable income. Medical, it's also important to, just in terms of the benefit determination again, which I haven't noted there, it's also important to know how much of your income is insured. And we kind of talked about that in the previous slide, but looking at, is it just your base? Is it your commission? And how they would calculate what your essentially your insured earnings would be for commission. Taking a look at all of that to understand exactly what it is that's covered for you. There are always terms in the policy that deal with medical records and assessments. They usually essentially give the insurer a right to essentially review what your medical records are, to get some assessments, to be able to send you to an independent medical examination, to have you assessed. There are requirements for this under the policy, and it's always good to get a bit of advice around them, but it's important to note that if you don't comply with the terms of the policy, that they can deny you benefit. So if you refuse to go to a medical assessment, they can, regardless of how disabled you are, they can pull your benefit. So it's important to know that. The other thing that's important is recurrence and how that's determined in your policy. So if you, let's just say you're off work for 2 years and you start to feel like, hey, I think I can start to get back into work a bit. And you go back to work and you're at work for say 3 or 4 months and you realize, you know what, I overestimated my abilities. I don't think I can maintain this. And you have to drop back down. It's important to look at recurrence because either A, you would need a new claim and have to go through the same process, or B, if you're still within that period of recurrence. So in this policy, it was defined as within 6 months of the ending. So when you kind of pass that threshold again, that 60% threshold, when you dip back below, if it's within that 6 months, it is the same claim that you've already applied for and been under for the 2 years previous. The rehabilitation incentive provision, they're often quite good about this, but it's important for you to know what is available to you under the policy. Oftentimes, if you're participating in a rehabilitation program, they may bump up your income. So although they're only required to pay you, and it depends on what your policy is, but we often see 60, 65, 70, 75%. They often have a rehabilitation incentive provision that can bump that up, to incentivize you to be participating in part of a rehabilitation program. We talked a bit earlier about the interplay between the pre-existing condition and kind of your entitlement. But here again, it's really important to know how they define pre-existing condition. And there is often a period of time for the pre-existing condition under which you are continually insured and not like accessing those benefits. It doesn't mean that you've not had any care, although you'll see below that there is also a separate condition for not having had care when your insurance took effect. But if you're still working full-time and getting massage, say, or getting physio for the condition, as long as you're not accessing those benefits in the long-term disability benefits in that first year, you would then qualify and it wouldn't be considered under this exemption. Some of the other limitations that we commonly see, you have to be careful about, if you want to reside outside of Canada, you need to be really, really careful. A lot of policies have essentially restrictions on where you can move and when, and you might need to get permission to move outside of Canada or be outside of Canada for an extended period of time. Some of them have restrictions on travel and needing permission. Again, we talked about not participating in treatment, medical or vocational assessments, also being a way to limit your coverage. And also if there was a planned leave of absence or layoff, that can be an exception as well. So it's important to keep these things in mind because sometimes they're just not things that you would think about. Like I'm a dual citizen between the US and Canada, and all of my family resides in the US. So if I was off work entirely, it's very likely I would want to go spend time with my family. They'd take care of me. But it's one of those things to be conscious of and to be aware of because it could affect your benefits under the policy. We talked about this a little bit earlier, but own versus any, again, it's commonly 2 years after those disability payments have kicked in, but that timeline is defined in the policy. So it's important to understand what that is. And again, it doesn't mean literally any occupation. You'll see here in what it's defined, where it's defined here is essentially that it's gainful employment, that you're essentially medically able to perform, that you have at least minimal qualifications. But and again, what that means will be defined in your own policy terms. Rehabilitation programs, graduated returns to work. I'm sure that many of you have been a part of these, and it's really important to think of a few key elements of them. One, again, that requirement to participate. It's important to be cooperative, but there are limits to that. So one of the things that often arises is it's really important to look at your policy, because there are often references to making sure that the rehabilitation program or the graduated return to work is medically supported. And often if you have a specialized condition, that's with a specialist. And it's really important because oftentimes you'll see them try to kick in a rehabilitation program or graduated return to work that's really just being guided by either a case manager or an occupational therapist, and not by a specialist that understands your condition. And so you end up with treatments that are contrary to the condition, which is very common for ME/CFS and for fibromyalgia. There are limited people that understand exactly what kind of treatments are needed for conditions like that. And so making sure that whatever you're being asked to participate in is not going to worsen your condition. And making sure that not just having the involvement of a specialist that's guided by the insurer, make sure that there is some level of involvement from your treating specialist, and that their recommendations for your treatment and accommodations are being considered. So basic termination of benefits. So if your claim is accepted, they can be terminated. And we kind of talked about some of the exceptions that kind of come out in the policy. So being careful that you don't tread on those. So being outside the country for more than 6 months without permission, et cetera. But they also terminate if you either attain enough recovery, and that doesn't necessarily mean that you have attained that recovery, but the case manager believes that you have. And we do see this one as a source of appeal, where if you had, so for example, if somebody is generally disabled from doing more than 15 hours of work, but they have a period of work where they start working a whole lot more because of the conditions of work, and it flared their condition and they dropped right back down, the case manager may look at that period of time and go, see, you could work more than you say you can, and then kick you off benefits. They have to give you a notice period, but you then would have to fight that with an appeal. And we'll talk about appeals in just a minute, but it's something that they have discretion to determine as well. You reach the age of 65. That's usually the average age of retirement, or considered the average age of retirement. This can, but rarely is, different. And usually where you see it be a little bit lower is in the more physical professions, where people don't generally go all the way to 65. We talked about it before, but the refusal to participate in rehabilitation or return to work, or if you pass away. Some basic tips when you're dealing with the insurance company, and these apply whether or not you've been accepted or denied. Keep copies of every document that you submit to the LTD carrier. They often will send you authorizations for access to all of your medical records, et cetera, and to be able to speak with anyone. We generally don't like those authorizations. You can always ask that they provide to you what their requested documents are, and then give them to them directly. Just make sure that you communicate this to them and ask what they need, and that you do provide them to them, so that you're not then seen as essentially not complying with the terms of your policy. Where this is particularly important is, it's difficult to talk about what's relevant and not relevant to a claim, especially when you're dealing with a condition that's so broad ranging. But oftentimes we see things in the records that deal with third parties, with very unrelated medical conditions that really truly have no bearing on the claim, but are sensitive. And those are the things that we usually try to keep out from the records. Obtain a copy of your completed employer and medical forms, so that you know what your complete package look like, because often they're sent from the employer directly to the insurer, or from the physician directly to the insurer. So make sure you get copies of those so that you have a complete idea of what your file looks like. Make notes of every conversation that you have with somebody at the insurance company. Get their name, include the date, get the time, and make those notes contemporaneously, because they will most assuredly be doing the same. And you'll notice this when you request your file. If you're denied, you'll see that they've taken detailed notes of all of their conversations with you, and it will be from their perspective. And you want to make sure that you have a written account of how you recall that phone call. You can also request that communications be in writing. I wouldn't take this as a first step, but it is certainly one that I have taken where I felt like there was a disconnect between the conversations that I was having with an insurance agent and what I felt were the facts. If they use a portal, which many of them now do for privacy reasons, make sure you save important communications outside that portal, because they often expire after a period of time, whether it's a couple weeks or a couple months. Make sure you save those communications outside the portal. Privacy. We've had this question arise, so we want to kind of address it. Just because you have a disability and you make an application for LTD disability benefits, and obviously those are often facilitated through your employer, it doesn't mean that you don't have privacy with your employer anymore. Your employer is not entitled to know the ins and outs of your medical condition. They're not entitled to know exactly why you've applied for LTD. They do, if you work part-time or you're going to continue to be off work, they do need something to understand what your accommodations are that are needed. And those should be clearly communicated by a physician, and not just directly by you, but by a physician. But they're not entitled to know the ins and outs of your condition. So preparing for an appeal. There are essentially two levels of appeal when you're dealing with an LTD claim. The first of which is internally within the insurer, you can appeal. And the second is obviously in filing a claim with the Supreme Court of British Columbia. The first level of that appeal, it is possible to sometimes overturn decisions there. It's obviously difficult because it's, again, within the insurer. But this is a place where we recommend at least getting some guidance from legal counsel on what to submit. And so it could be additional documents or reports that might be beneficial. It could be taking over the communication with the insurance carrier. But it's important to get a little bit of guidance, because it may be possible to not have to go that next step to file a legal claim and to be able to deal with it through the internal appeal process. So Susan and I had been dealing with one last year where we got collateral statements from witnesses. We did a detailed cover letter as to why their appeal was not appropriate, or why their denial was not appropriate and why we were appealing it, with several collateral witnesses and additional medical evidence. And it was quickly overturned. So it is possible to get it overturned at that step, but it's important to make sure you put together a case at that step and not just appeal and kind of let them run with the same evidence. There is usually 1 year to make an internal appeal from denial, but that timeline is set out in the communications. And so it's really important to know when they deny your claim, they will let you know how long you have to appeal and who you have to appeal to. It's important to take note of those details. Make sure that you collect your medical evidence. So having copies of your files is really helpful. But also, when you are denied, get a copy of your entire file with the disability carrier. This will help for you to understand exactly how they got to the decision that they made, because it'll often include communications between various agents within the insurer. It'll include their communications with you. It'll include what they considered. And so that can be really, really helpful, and it will be essential if you do go and get some advice. If you take that next step and you go to the Supreme Court and you file a legal claim, it's important to note that you have 2 years from the date of denial to make that claim. Otherwise, you will lose the right to do so. So just really quickly, I don't want to get into the nitty-gritty of making a legal claim, but the basic process is you would file a notice of civil claim, which is essentially a document with the court that essentially lays out the claim and the legal basis for it. You will serve that on the insurance company. The insurance company that will then respond either admitting or denying various elements of your claim and their legal basis. And then once those documents are exchanged, it essentially is called the pleadings closing. And what that does is it generally triggers the discovery process. And so that initial set of the discovery process is an exchange of documents. So all relevant documents that are within your control or their control, you exchange those, as well as kind of a specialized list. But it also gives you the ability to do an examination for discovery, to do interrogatories, which are essentially written questions to the other party, or notices to admit, where you send essentially what you say are the facts, and they have a prescribed period of time to respond, either admitting or denying them or clarifying them. And after that prescribed period of time, if they do not respond, they're deemed admitted. These claims often end in a settlement, and often with a mediation after an examination for discovery. It is possible to go to trial, but most often they end in settlement. If you settle at mediation, it's often a lump sum, but it could also be reinstatement of benefits, depending on where you're at in the process, and what those benefits are. So we're going to do the questions at the end, but I will now kick it over to Susan for WorkSafeBC.
Okay, thanks, Whitney. So my topic is WorkSafeBC, and I'm offering this as kind of a roadmap, actually. It shouldn't be taken as legal advice, but hopefully it'll give you some tools to understand and participate in this process if you're unfortunate enough to end up in it. WorkSafeBC is governed by a BC statute, the Workers' Compensation Act. Its policies and procedures are set out in the Rehabilitation Services and Claims Manual, which is accessible online. Under the Act, WorkSafeBC offers income replacement in the form of total temporary disability benefits, wage loss benefits, to workers who are injured in BC, who get injured on the job, and that includes developing an occupational disease as a result of exposure to a hazardous substance. So, for example, that would be a fireman who is obviously exposed to hazardous substances in their work and ends up with lung cancer. The temporary disability benefits are also offered to workers who are injured on the job outside of BC if certain requirements set out in the Act are met. One of them is a requirement that the worker themselves has to live in BC, and another requirement is that the employer has to have a place of business here. There are a few other steps as well, but those are kind of the main requirements. Okay. If WorkSafeBC decides that a worker's TTD benefits, total temporary disability benefits, if they decide that their temporary disability has become permanent, it will at that point do one of two things. And this is basically a case manager who decides what to do with the file at this point. The case manager will either refer the worker's file to the voc rehab department at WorkSafe to determine whether or not the worker would be entitled to, or in need of, retraining or any other voc rehab assistance. Or there will be a referral to the Disability Awards Department at WorkSafeBC, which will be in charge of assessing the worker for a disability pension. In addition to all of the things that I've talked about, WorkSafeBC may also cover the cost of various healthcare expenses, such as medications and treatment for an injured worker, if they're required because of the injury. Let me just say that they are supposed to cover them. That sometimes doesn't happen. There are certain limitations with respect to workers who are on opioids for an extended period of time. And the other problem with these benefits that they're supposed to offer but sometimes don't is that they don't pay the full cost back to the worker. So in other words, someone may be going for physiotherapy. It's totally related to the injury they sustained at work, but WorkSafeBC reimburses it at a much lower rate than the worker actually pays to the physiotherapist. The other important thing to remember is WorkSafeBC doesn't pay a worker anything at all for pain and suffering and loss of enjoyment of life. I get a lot of people calling me saying, well, I don't understand this decision. Where's my award for pain and suffering? And I have to inform them that sadly, that is not part of the WorkSafeBC process. Who has coverage with WorkSafe? Well, if you're an employee in BC, you're likely covered through your employer because it's actually mandatory for the employer to have coverage. And also, if you're a self-employed proprietor in BC, you may be able to purchase coverage for yourself. That would be optional personal protection. So in other words, it's not required, it is optional. Then there is a definition that people can run into problems with, and that is in the course of employment. In order to qualify for WorkSafe benefits, the worker has to have sustained their injury or been exposed to the hazardous substance causing their disease in the course of employment. What this means is that the injury or the exposure to the substance has to have happened in a time and place and during an activity that is consistent with the requirements of the worker's employment. It doesn't always require that the person is an employee of the company, by the way. There are decisions by the Workers' Compensation Appeal Tribunal that help to determine what might be in the course of employment for people such as consultants, traveling employees, and even volunteers. People can often fall down on this or encounter difficulties just with this definition. One example I can think of is a young fisherman client of mine who was told that his claim was being rejected because he had incurred the injury when he engaged in horseplay. And of course, it wasn't horseplay. It happened when he jumped from the dock into the boat. He landed funny on one foot and broke his ankle. But we had all of the other fishermen on the same boat saying, well, this is how we do it. We're young, fit guys. We typically jump into the boat. And yes, we have to actually get into the boat to do our work. So we did manage to get that decision overturned. In order to qualify for WorkSafe benefits for an occupational disease, first of all, WorkSafe has to recognize the disease as an actual occupational disease. The disease has to be due to the type of work the worker is doing, or has done in the past. And the disease has to be caused by exposure to a hazardous substance in the workplace. And the Act lists certain diseases which WorkSafe presumes are caused by workplace exposure in the face of no evidence to the contrary. And as I said before, that would include such things as primary site lung cancer in firefighters. The Act actually does set out this sort of information, and it's kind of frightening the number of things that firefighters may actually develop as a result of their exposure to hazardous substances. And WorkSafe actually recognizes that, which is also kind of amazing. How to apply for WorkSafe benefits. Do not miss the limitation period.
This is kind of a theme.
Yes, basically.
For all of these.
Yeah, exactly.
Yeah.
Because there's very little sympathy or mercy if you do miss it. So you have 1 year from the date of the injury or the disability arising from the disease to make a WorkSafe claim. The best course of action, though, is report the injury immediately to your employer and complete an application for compensation, which is available online. Send the completed form to WorkSafeBC as soon as possible. And if there were witnesses to the incident, obtain their names and contact information, and please keep that information. Don't lose it. It's really important. Your employer is also required to report the injury to WorkSafe as soon as possible if the worker missed time from work or needed medical attention outside of workplace first aid. A lot of employers will submit the forms even if that is not the case, just to be on the safe side. Sketchy employers, not so much, but good employers, yes, they want to cover themselves. Possible extension of a limitation period. It's not very common, but in certain circumstances, WorkSafeBC may agree to extend that 1 year limitation period. And that would be perhaps in a case where a worker can actually prove that their employer strong-armed them into not making a claim. And unfortunately, that does sometimes happen and would be considered a special circumstance. The only issue with that is, unfortunately, the employer will most likely deny that that was the case. So again, witnesses can be important. Wage loss benefits are set at 90% of whatever the worker's net earnings were at the time of the injury or when the disease became disabling. If the worker is disabled from work for more than 10 weeks, WorkSafe does something called a 10-week wage rate review. So what they do at that point is not just consider what the worker was earning when they were actually injured, but they'll look at the previous year's earnings to arrive at an average wage rate. This can sometimes not be great for the worker because maybe they didn't work too much, didn't earn much in the previous year. But if that's the case, they do have the right to ask WorkSafeBC, to take previous year's earnings into account if they were higher. And WorkSafe will go back typically up to 5 years. It is the worker's responsibility to provide WorkSafe with that documentation, though. You can't just say, well, I made more money in the previous 5 years. Get them your income tax returns as soon as possible, whatever else you have as documentation confirming your previous year's income. This wage rate review is really, really important because it also impacts the amount of the disability pension that a worker may receive from WorkSafe if their disability ultimately becomes permanent. When do those temporary wage loss benefits terminate? One of two things, when one of the two following events occurs, WorkSafe decides that the worker has recovered from their injuries, or WorkSafe decides that the worker has plateaued in their recovery. In other words, the worker is not expected to make any further recovery. And if WorkSafe determines that the second event has occurred and that the worker has plateaued, it may deem the disability to be permanent. It's supposed to deem it to be permanent anyway. If WorkSafe decides that a worker has plateaued, the worker's case manager will then either refer the worker's file to the Disability Awards Department for a pension determination or to the Vocational Rehabilitation Department if the case manager determines that such assistance is appropriate. And throughout my talk, you will perhaps have noticed that I use the terminology that WorkSafe will do this, WorkSafe will do that. So you should have a clear understanding by now that they are really fully in charge and they run the file the way they see fit, which is not always the correct way, by the way. Once this happens, the plateau decision has been arrived at, and the worker is referred on to further departments. The worker will still continue to get those income replacement benefits. It doesn't mean they're not going to get any more money. I've often had people phoning me saying, well, I got this letter from WorkSafe saying that my wage loss benefits are going to terminate. What are they talking about? I'm still injured. But in fact, the letter will also explain, you're being referred out. But it may not actually tell them, don't panic, we're still going to be paying you. It just means that the description of the benefits changes within the WorkSafe system. But the worker generally shouldn't even care about that because they'll still be getting the same amount of money. There are two ways for WorkSafe to calculate disability pensions. The first one is a loss of function method, and the second one is a long-term loss of earnings method. The loss of function method is really strange because it's not really a loss of function at all. It basically requires WorkSafeBC's disability department to determine what percentage of totally disabled a worker is, with a totally disabled worker being considered 100% disabled. It isn't based on an actual loss of income sustained by the worker. It is to be applied only where the worker is not going to sustain a future loss of earnings as a result of their permanent partial disability. For example, a lawyer such as myself could somehow perhaps lose a finger as a result of a workplace injury, but I would still be able to work as a lawyer, and that would presumably be without sustaining any future income loss. Nevertheless, I would be entitled to a disability pension for a permanent partial disability because I had lost a finger. WorkSafeBC uses something called the Permanent Disability Evaluation Schedule, which is set out in its manual as a guide in arriving at the scheduled amount. The schedule sets out various injuries and corresponding disability percentages to be used as guidelines. The issue is this is only a guide. It's also very limited. It also does not include every type of disability, and it falls quite short when it comes to more what WorkSafe describes as subjective injuries. For example, mild traumatic brain injuries, fibromyalgia, CFS, ME. And the determination of the disability percentage is ultimately left to the discretion of WorkSafe's Disability Awards Department, which is very scary. Okay. The loss of earnings method makes more sense. It is designed to cover workers who cannot return to their pre-injury occupations such that they will sustain a true income loss. So WorkSafeBC's Vocational Rehabilitation Department is involved in these situations. They will then decide whether the worker, first of all, can be retrained for another occupation. And they're basically looking for the most minimal, inexpensive retraining that they can think of, or the worker is able, despite the worker's disability, is able in the eyes of WorkSafe, I should say, to do some other job for which they require no retraining. This other job may not pay as much as what the worker would have made at their pre-injury job, but WorkSafeBC will deduct from the worker's pension whatever amount it determines that the worker could earn at this other occupation, which I should say WorkSafe has essentially chosen for the worker. If a WorkSafeBC disability pension is based on the loss of function method and the amount is less than $200 a month, WorkSafe may pay it to the worker in a lump sum. That's called commuting the pension. If it will be more than $200 a month, the worker can request that it be paid in a lump sum, but this is only if it's a loss of function pension. They will not do that with true loss of earnings pensions. And they will only do this in any case in very limited circumstances. One example is that if the worker is actually able to convince WorkSafeBC that they have a viable business plan, that they want to start their own business, they have to show that this business will support them appropriately financially. And this is really, really difficult to do. I've seen people prepare very complex business plans and they still get rejected. You should also be aware that if you do get the pension as a lump sum, it's going to be the net present value of the pension. And it's determined by an actuarial calculation. So you don't just take the amount that you're getting every month and then multiply it by the remainder of the years you're going to get the pension, and that's the amount. It's going to be less than that for sure. WorkSafeBC has two internal levels of appeal if you disagree with the decision. The first is the review division, and if you lose at that level, you can appeal to the Workers' Compensation Appeal Tribunal, which is WCAT. Except for vocational rehabilitation decisions. The rehabilitation decisions are the only decision that you can only request a review of. You can't go beyond that to the appeal tribunal. And I think that's probably, that was not always the case, but I think it was probably made the case because those decisions are quite often the ones that are most needing to be appealed. The worker has to communicate the request for review in writing directly to the review division. You have to communicate directly to WCAT in writing if you want to do an appeal. You have to attach a copy of the decision you're contesting. The forms can be accessed online. You can advise the review division and WCAT whether you want an oral or a written hearing. The forms actually allow you to do that, but you should know that it's up to them to decide how the hearing will proceed. Review division hearings are generally by way of written submissions only. But I would say with WCAT, request an oral hearing, and quite often those are oral hearings rather than by way of written submissions. They can be very successful simply because it allows you to actually present more evidence. You can bring witnesses in support of your appeal, for example. You must provide that information to WCAT in advance of the hearing if you are going to be bringing witnesses. Your employer will be invited to participate in both the review division and WCAT hearings. I have not had that happen very often. You should also be aware that you can provide additional medical evidence for either the review division or WCAT. If you do obtain a medical legal opinion from a doctor, you're going to have to pay for that yourself. However, if the review division and WCAT feel that it was appropriate for you to obtain such a medical report, they can make a direction to WorkSafe that you be reimbursed for at least some of the cost of that report. I think the maximum right now for a medical legal opinion is $2,400. And of course, that never covers the full cost. But at least it's something. There is no way that you can claim legal fees, by the way. It's only a medical report that they'll reimburse you for some of. You're certainly entitled to be represented at both the review division and WCAT hearings if you wish to be. That doesn't need to be a lawyer. You can have someone else as your representative. But I think, quite honestly, getting some legal advice would be entirely helpful at that point. If you get the legal advice early on, you may not have to go through all of these levels of appeal. Okay. And the limitation periods for reviews and appeals are really strictly enforced. If you want to get a review of a WorkSafe decision, you have to notify the review division in writing within 90 days of the decision. And if you want to appeal a review division decision to WCAT, you have 30 days to notify them in writing. If you do miss the deadline, you can request an extension from the review division or WCAT. Such requests are granted in only very limited circumstances. I had one case where the client who retained me had been on a massive amount of morphine and bedridden at the time that he should have requested a review. Nevertheless, he had actually hired somebody to do that for him. It was not a lawyer. It was someone whose claim to fame seemed to be that his wife had at one time worked for WorkSafeBC. And the gentleman actually lied to my client, and we had that in writing saying, oh, yes, I did request the review. I don't know what they're talking about. Of course I requested it. Well, he never did. And that was one where we did request a review of the denial, and that was successful. He had really done everything he could, and it really was not his fault that that had happened. If a worker loses at the WCAT level, they can apply for judicial review by bringing an application in BC Supreme Court. And even if you do choose to represent yourself at this application, I think it's important to get legal advice, because there is a burden that you have to meet when it comes to judicial review of administrative tribunal decisions. And that's something that a lawyer can talk to you about. I'm now going on, and this is going to be shorter, I promise. It's CPP-Disability benefits. This is a program that's an income replacement program operated by Service Canada. It does not cover the cost of any medical expenses whatsoever. The criteria to qualify for CPP disability benefits are: you have to be under 65, you have to meet their definition of disability, and you have to have made contributions to CPP for a requisite period of time. If you have elected to take early retirement benefits through CPP, you can still qualify for some additional benefits for the ages between the ages of 60 and 65 with CPP disability benefits. You have to have a mental and or physical disability that is severe enough that it stops you from doing any type of substantially gainful work. And the disability has to be either long-term or of indefinite duration, or is likely to result in your death. If you do return to any form of paid work, there are strict annual earnings limits and reporting requirements. You really, really have to be mindful of this. Reporting requirements are required at a threshold of $6,600 gross annually, and it may affect your benefits up to a ceiling of $18,508.36 per year. And beyond that amount, the $18,000, you're likely to be deemed no longer eligible for disability benefits. You also have to report to Service Canada if you're doing other things, which people might not even think of as something that they have to report. But if you're volunteering, or if you're attending school, or doing some combination of those two for more than 15 hours a week over a period of 4 or more months, you must report that. Monthly CPP disability payments currently fall between $558.74 and $1,538.67. The base amount is the lower, the $500 some odd dollars, and the maximum amount is the $1,500. The maximum amount that you get does depend on how much you've paid into the CPP plan. So the basic amount is the same for everyone. The rest is based on your actual contributions. And of course, they have a calculation that they do. They look at your CPP retirement pension from the point when you left your job and multiply that amount by 0.75. The payments can be made to you retroactively. Some people don't apply when they should, but there is some leeway there. CPP will go back 12 months, so it's 11 months prior to your application, plus the month that you applied. Again, it doesn't really make sense to delay do it on time. The problem is that you can be sitting waiting for several more months after you apply to actually get a decision. You have to submit 2 forms. One is an application for a Canada Pension Plan Disability and a medical report for a Canada Pension Plan Disability benefit. Both of these are available on the Service Canada website. You have to complete sections 1 and 2 of the medical report, and your doctor or nurse practitioner has to complete sections 3 to 9 and send it to Service Canada. Service Canada will pay up to $85 directly to the doctor or nurse practitioner for completing the medical report. Any additional charge would be your responsibility. Keep copies. This is pretty much the same thing that Whitney said. Keep copies of every document that you submit to Service Canada. Obtain a copy of the completed medical report from your doctor or nurse practitioner for your records, and make notes that you have of any conversations you have with anyone at Service Canada, including the agent's name, the date, and the time. And actually, I should have said that with respect to the WorkSafeBC stuff as well. Throughout the course of the claim, it's a very good idea if you do exactly that. And when you get your WorkSafe file, or when you get access to it, which you should have as the worker, you will see that there are copious typewritten notes made by whoever you talk to, which may not set out accurately the subject of the conversation. So having your own contemporaneous notes is really important. Many initial CPP applications are rejected, only to be overturned upon review or appeal. In other words, please don't give up when your initial application is rejected. Apparently many people do, and that's sad because I think that a lot of them probably would have been entitled.
Same thing with LTD.
Yeah, just don't give up. Honestly, some of the decisions are just completely bonkers. And it really bothers me that someone who is very ill may be getting a decision like that, and they're already such a mess that they're like, oh God, then they give up that as well. If you can't do it yourself, please get somebody involved to assist you. If you do receive a denial, remember you've got 90 days to request a reconsideration. The reconsideration will be done by another agent in the same department. Surprisingly enough, sometimes those do succeed. Your request has to be in writing. And again, I'm advising that you talk to legal counsel at this stage, just to make sure that what you have submitted in support of your request for reconsideration is sufficient. If this doesn't succeed, you have the right to appeal in writing to the Social Security Tribunal of Canada within 90 days from the date that you get the reconsideration decision. And that form is available online on the Tribunal's website. The Tribunal actually has an excellent website. These appeals usually proceed by way of oral hearings at which you are entitled to be represented. Again, it doesn't have to be a lawyer. It can be somebody else. We do recommend that you get some legal guidance at this stage with your written and oral arguments, and ensuring that your supporting documentation is in order, even if you intend to attend the oral hearings alone. You have to let the tribunal know well in advance if you have a representative who will attend the hearing, as well as if you are bringing witnesses or a support person. You are entitled to a support person as well. And you can find precedent case law that you may wish to rely on at the hearing on the tribunal's website. I should mention one of the odd things, just to go back for a minute to WorkSafe. WCAT also has all of its decisions accessible. The odd thing with WCAT, though, is that their precedents are not considered binding on them. This is very weird to lawyers, because whenever we go to court, we look for case law that, you know, is similar to our case, and then we argue that the court should find the same way the court did in this other person's case. Unfortunately, WCAT doesn't operate that way, which I think is really strange. But nevertheless, their decisions are available online, and you may be able to glean some knowledge or, you know, hang your hat on something that they have found. And
they will often consider them. They're just not required to follow them.
Exactly. Yeah. They're just not binding. So the process in making appeal to the Social Security Tribunal is you have to complete a notice of appeal, Income Security General Division form, which is available online. And the General Division is their first level of appeal. You send it to the tribunal within 90 days from the date you get your reconsideration decision. You can indicate on the form whether you want an oral hearing or a hearing by way of written submissions, but it is up to the tribunal to decide how to proceed. In this case, Employment Services and Development Canada will be the respondent in your appeal, and they will file a response to whatever you have submitted to the tribunal. And this is interesting because basically it means that the government is your opposition. The government is generally rather imposing, and I think at this point you may be wishing to consider whether or not you need to retain counsel. You do have a right to reply in writing to whatever submissions you get from, I'll call them the ESDC, which is the government. They do have lawyers, by the way. The last one that I did was at a hotel in Surrey, and the government had flown out a lawyer from Ottawa to conduct 2 days of these hearings. So you should be aware that they may well have a lawyer involved. All of the documents are sent to the tribunal in advance of the hearing. That means you send yours, ESDC will send theirs. The tribunal takes care of providing all of the documents to both parties. So in other words, you're not having to communicate with the government yourself. The tribunal takes care of it. Once the hearing's been held, either through written submissions or orally, you can expect to receive a decision from the tribunal within 60 days of the hearing. And the same thing applies here with these hearings. If it's an oral hearing, you can certainly bring witnesses. You know, that's something you have to notify them about prior to the hearing so everyone's aware. And if you've got documents, medical evidence, whatever it is, try really, really hard to get that stuff into the tribunal well in advance of the hearing so that there can be no suggestion by the government that, you know, they now need some time to respond or something of that nature. You don't really want to encourage delays because this is a long process. If your appeal isn't successful, the tribunal does offer a second level of appeal to its appeal division with permission. You have 90 days to submit an application to the appeal division from the date of the decision of the general division, the general division being the first level of appeal. So in order to get this permission to appeal to the second level, you have to show the appeal division, convince them, I should say, that the tribunal didn't follow a fair process, acted beyond its powers, or didn't exercise its powers, or was wrong in law or fact, or both. Obviously, I think at this point, it should be clear that getting legal advice before making your submissions is highly advisable, and probably getting legal advice once you receive the response from the government would also be a good idea. If your appeal to the appeal division of the tribunal is unsuccessful, you can then appeal to the Federal Court of Canada. That's where you would appeal from the denial after a granted hearing, or to the Federal Court of Appeal, which is an appeal from the denial of permission. And actually, the tribunal is good in this, in that when they send you your letter, if it is a denial, they will say, okay, these are the next steps. You have X period of time to do this, or X period of time to do that. So they'll even inform you which level of court you're going to have to go to, which is good. I think they actually handle things quite well, because they are well aware that many people are doing these sorts of things themselves and do need, you know, a little bit more guidance perhaps. So.
And again, the tribunal website is really helpful if you're in the middle of that process. Mm-hmm. So definitely take a good look at all that it has to offer.
Yeah. And also I should mention disability, I think it's called Disability Alliance BC. They will offer some help to people who are going through this process if you meet the income requirements. So that's also something to consider. It's a, you know, a free service. I think the only problem is that it's not that well funded, and you may find that they just don't have anybody available to help you within the time that you need. So there is also a free service with respect to WorkSafe claims. It's called the Workers Advisors. They have quite a decent website. Again, well, they are separate from WorkSafeBC. They are provincial government employees, but not WorkSafe employees. Again, they have a very high caseload, and you may find that it's not that helpful just because the funding isn't there, which is unfortunate. So.
Okay.
The other interesting thing with CPP disability benefits is if you have children under age 18, you will also be entitled to an additional benefit for the support of each child. You have to apply for that, obviously. The monthly amount for each child is currently $281.72, which is adjusted annually for inflation. If your child is between 18 and 25, but enrolled in a full-time recognized educational program, and you have to prove that that is the case, and dependent upon you, you will still be entitled to the child benefit payment. And depending on your child's living arrangements, for example, if the older child is living on their own, the child may be able to receive the child benefit directly. Whitney already touched on this, the impact of CPP on other income benefits. If you're getting disability income from another source, such as an LTD insurer, they may require you to apply for disability benefits under the terms of your policy. And if you succeed, the insurer may be entitled to reduce your monthly LTD benefits in accordance with the terms of your policy. That's the case also with WorkSafeBC. Provided that you're getting WorkSafeBC benefits and CPP disability benefits for the same disability. If it's a completely different disability, there is no offset, but they may be reduced if you are getting CPP benefits, CPP disability benefits for the same injury. And WorkSafeBC doesn't take into account any amount that you may receive for dependent children when it calculates a possible reduction of your WorkSafe pension. And those are our submissions.
Okay, sorry. I know I think we have about 23 minutes and we're going to get to as many questions as we can. I said this at the beginning, but I think many people might have joined after that. We can't advise on any specific individual circumstances. We will get to as many general questions as we can, and get as far as we can go. Let's see. Okay. Let's see. I have been approved for LTD benefits until I'm 65. I now have to apply for CPP disability. The government confirmed I don't have enough credits to qualify for CPP disability. What happens to my LTD benefits when I get denied for CPP disability? They are only deducted if you qualify for CPP disability. The requirement in your policy is usually just that you apply. And then if you are accepted, they're deducted. If you are denied, then it shouldn't impact your LTD benefits because you've applied and done what you need to do to kind of essentially help the insurer reduce their obligations. Let's see. A lot of thanks for Dr. Arsenault, which I can, I don't think I mentioned this at the beginning, but I am also a patient of Dr. Arsenault, and I know just how great he is, and have also dealt with him in a professional capacity in some of my cases. And it's really helpful to have somebody that is A, such a wealth of knowledge, but also B, is helpful at navigating the various legal processes that people that are on disability end up encountering or that end up in various claims. Let's see. Again, will LTD kick me off my benefits if I'm denied CPP disability? No, that's a separate assessment. So LTD assesses disability under their contract or the policy with you. CPP disability has that definition of disability that is their own assessment. Being denied from one does not mean you will be denied from the other. And if you are denied from one, it doesn't mean you'll get kicked off the other. it looks like there's a question about LTD and top-up earnings and whether payments decrease by that amount. And looking at volunteer research or honorariums. The one thing I would note is the same thing, and I think we talked about this with respect to CPP disability, but looking at volunteering and schooling and being conscious of that also having the potential to impact your assessment under an LTD claim. So if you're unable to work, but going to school 30 hours a week, they could look at that and assess you as being able to work. When it comes to any kind of compensation for that kind of work, I think it really depends on the specific terms of the policy and the specific terms of the honorarium. So I think it's important to look at whether or not that would qualify as income underneath your LTD plan. And if it does, it's likely to be offset. LTD, can an insurer claw back a non-taxable windfall like a lottery winning? I don't think that would be anything that would be qualified as income. So you would look under the specific terms of the policy and your LTD policy as to what can be offset. It'll likely tell you in those terms. So oftentimes what we will see is we'll see CPP-Disability, and whether there's any kind of WorkSafe, whether you're earning any kind of income, because it's meant to, what you have contracted for with the insurer is a replacement of the income that you should have earned. And regardless of, I would be surprised to see something like a lottery winning. I can't say because I haven't seen the policy, but really what that contract is you're saying, I'm going to pay you this amount of money every month. And should I become disabled and not be able to earn my employment income that's defined within that policy, you would then pay me the employment income. And when we're looking at something like just logically thinking about lottery winnings, whether or not you're working, you would be entitled to them. So if it's something completely different than you kind of working into the future and that being something that would be captured under the same kind of contractor policy. I'm not sure if that was quite direct, but I would doubt that it would include something like lottery winnings, but without reviewing the policy, I can't say no. But usually it's anything that's meant to deal with your income, and lottery winnings are more of a windfall and not income.
Yeah, they're not taxable, so.
Any insights on getting a new job and what to disclose or not? Also, when to disclose illness, disability to a new employer. You're not obligated unless you have accommodations that need to be considered in your setup to disclose a disability. I think it's a very personal and unique decision. Many people do not. I personally did with my previous employer, and now obviously Susan is very well aware of my condition. And so I will say that Susan has quite a unique understanding of CFS-ME and fibromyalgia, and she's, although not experiencing the condition, is aware of the impact. I think it's a very personal decision, and you're not required to do it. So it's something that I would say most people generally choose not to accept when it comes to accommodations and making sure you have the physician's recommendations for those accommodations. Is there any way to increase LTD earnings over the years, as you would have had raises every year and because of inflation, or will it be the original amount monthly forever? So this is that kind of COLA term that we were talking about. And unfortunately, a lot of policies, and the policies that we were looking at, and the reason there isn't an example of a COLA term is that there is not a COLA term in that policy. So that policy would be limited to the same amount. So it would be, if your benefit amount is capped at, say, $4,000 a month, that will continue to be true, and it will obviously lose value over time. This is why those COLA terms are really, really important in policies. They don't take into consideration generally raises. Once that benefit is triggered, what you would really only see are the COLA increases versus any kind of raise increases. If you are looking at the original policy before you ever had a disability and looking over time at the income that you would have essentially continued to grow in your time at work, that's something that would be important to look at your insured earnings, which is that other term, because that can go up. So if you started out making $50,000 and then you got a raise, and by the time you had your disability, it was $75,000. It may not necessarily be that. You need to look at what was insured and what was reported to the insurer. Is there an age limit for LTD? It's usually that 65. You look at the policy specifically, but usually the kind of when the LTD benefits terminate is usually that age of 65, and that's because it's the usual age of retirement. But it would be defined under the contract, but it will be there. There's a question as to whether or not, if your extended benefits and your LTD benefits are with different companies, whether or not the extended benefit, I assume this is the premiums, would be covered. And I think that's really going to be dependent on the terms of the policy. It's obviously much more likely if they're with the same company. If they are with different companies, I think it's really going to depend on exactly how it's termed in the LTD benefit policy, because the LTD benefit policy would determine what they would be willing to cover. What if we are unemployed or a contract worker? There are individual, not group policies for LTD. Obviously, if you are a contract worker, whether or not you have benefits under an LTD plan or whether it's WorkSafeBC, and we talked about that optional personal protection, it really matters on whether it's really dependent on whether or not A, you had an individual policy, or B, you were paying for independent WorkSafeBC coverage. That is not the case with CPP, although when we're talking about being unemployed, it really depends on how long you were unemployed, because remember, when we're looking at whether you qualify for CPP benefits, it also looks at your contributions, and it doesn't have to be, the year before, but I think it's last 3 years of 5. Yeah. And then I think there's another consideration as well, but you have to have worked within a certain period of time, a certain number of years within a certain period of time. Question is, who should we get the full policy from? My employer and the insurance company keep pointing at each other. Those are the two people that you would generally get it from. Sometimes and often there is a broker that goes between the employer and the insurance company, and they should also have a copy of the full policy. If you're making this request and you're getting pushback, make it in writing and make sure that you're being consistent and following up. I just found out that my LTD policy deducts the amount I received from CPP-Disability. That's really standard. No one told me, and I missed it in the fine print. I now owe, this is an important one to keep in mind. Absolutely. They can claw back benefits. So if you're receiving LTD and CPP disability, it's important that your LTD carrier knows about what benefits or income that you're receiving. So that term that we were looking at, the offset benefits or the offset income, it's important to look at what qualifies and make sure you're reporting it so you don't run into a circumstance like this, because it can be really hard, especially when you're on disability benefits, because they never cover the full amount of your income. It can be really, really hard when you're living month to month to have something like that clawed back. Let's see. Do you want to field this one?
What can we do if CPP takes forever? You applied over a year ago, not received anything. I don't know what they mean by escalating. You've submitted new medical documents twice, but you are on LTD benefits already. So, I mean, it would be your LTD insurer, presumably, who made you apply so that they can reduce your monthly amount. So, I don't think that really is going to affect the amount you get. Wondering how they can claw back my survivor's pension. I honestly don't know anything about that. Sorry, I've never encountered that.
I don't know anything about survivors' pensions, but oftentimes they can stack. So with CPP, so like when we're looking at the CPP retirement benefit, it's also, you can also stack that with your CPP disability benefit if you're in that period of time where you can take early retirement between 60 and 65. So I don't know that that's specifically true for the survivor's pension, but it would be important to know and understand if that's possible as well. And I think I think what I'm understanding from Susan is there are a lot of delays in all of these processes and in these appeals, and it can be really, really frustrating. When you're dealing with CPP, though, oftentimes it would deduct from your LTD, so the financial impact might not be as significant as that delay feels, if that makes sense.
Yeah, it wouldn't actually affect income, but typically, I mean, I would say that typically it can take around 4 months to get the initial decision from them. So I really can't, I don't know why this is taking so long or why documents have been submitted twice. I'm sorry, that would be something that I can't actually comment on. My experience has just been around 4 months, so.
Okay. Someone is asking if they're going to be able to get the slides for this. I don't know. That's probably a good question for Dr. Arsenault.
Yep. If you share the slides, we give them to the patients.
Yep, we're happy to share these slides if they're helpful. And the next comment is complex stuff. And can we speak slower? Yes, I'm so sorry. We were trying to rush through to get you guys all the information, and it's 3 very complex topics. And so I'm sorry, but yes, we will provide the slides if they can be at all helpful. And keeping in mind that the terms for the LTD are terms from a very old policy and just meant to be examples. They will be different from the terms in your policy, just as kind of a caveat for providing the slides.
And the person who's applied for LTD and been denied and is appealing should apply for CPP disability now. Yeah.
Absolutely.
Go ahead.
And I would say that I wouldn't even necessarily tie those 2 things together. I don't think you ever have to wait for one to apply for the other. So if you're 6 months into your disability and you've gotten kind of the guidance that you're going to be off for at least another year, and who knows what it'll look like after that, which I know is a common recommendation when you have MECFS. Start applying for CPP disability now. Don't go ahead and wait. Just make sure that you go ahead and apply right away.
Definitely.
Definition of disability, it says, if it does not mention how much percentage of work the person is not able to complete, could you please let me know what that means? It will usually either say a percentage of work or a percentage of your income that you've brought in. So there should be a term in the policy. It should even be in the policy booklet. There's usually that very first page that gives you a summary of your benefits for LTD. It should define what that percentage is for disability. And usually it's somewhere in the range of 50 to 60%. But it varies based on the policy, but it could be a percentage of the work you can't complete or a percentage of the income you're not receiving.
I have a quick question for you, Whitney.
Yeah.
So what I usually recommend, if I know somebody's going on long-term disability, is I get them to apply for CPP at the same time.
Yeah.
And one of the reasons for that is that CPP in the definition says any occupation. What I've found is that at 2 years, it's a lot easier to navigate that 2-year point if they already have the CPP in place than if they don't.
Yeah. And we do see that sometimes there are delays if somebody is now being pushed by their LTD carrier to apply for CPP, because CPP takes some time. And Susan's experience has been about 4 months, and we've just heard from somebody where it's about a year, but that determination takes some time, and it can ruffle some feathers with LTD if they're expecting you to apply and you're months out and waiting on a determination still. So I like that advice to apply when you apply for LTD. I think that's smart. And again, it goes back to that. So when we're talking about any occupation, what Dr. Arsenault was just saying, it goes back to that definition in the LTD policy where it switches from your own occupation having a disability to any occupation and having a disability, because for CPP, they don't consider whether it's just your job, it's any job.
Yep.
And so it'll be really, really important to, it can help to ease that. And it's quite commonly known that the CPP threshold is quite high. And so if you have a positive CPP determination and you end up having to appeal or deal with LTD down the road, that can also be helpful.
They're entitled to their file.
Oh, sorry. Let's see. Can you?
Oh, no, that's not that one. It was, do we have a right to request records?
Oh, you
Yes,
absolutely
definitely.
have the right to request your file from Canada Life or from
Yeah.
any other LTD provider. No, you can, and you'll be amazed at what you find. They're required to put all of their communications and their internal communications into that file. And when you get the file, it will have all of that. And so if you've been denied, if you get an LTD denial, request that file right away. And you can just request that in writing right to your case manager. And just let them know you want a complete copy of your file, and you're absolutely entitled to it. Let's see. When the LTD company asks for a functional assessment, but sends you a form for Dr. Arsenault to say that it's fine for you to participate in said functional assessment, how do you navigate that? I think there's a couple things here. I think that usually a functional assessment looks something like what's called a functional capacity evaluation. And it's a brutal day for anybody with a disability, but especially with somebody who has energy envelope issues. It is usually a full 6 to 8 hour day with a full battery of tests. It's something that I'm sure Dr. Arsenault is familiar with. But what I think is here is probably having Dr. Arsenault give the recommendations for what he feels are your limits and not being pushed around by the LTD company to say, you know, you should be able to attend this 6 to 8 hour examination. It's important that all of these assessments are guided by the recommendations of the specialist that you're seeing. So if Dr. Arsenault says, look, you've got a 1 or 2, and this is just an example, I don't know your specific set of circumstances, but you've got a 1 or 2 hour window in which you can be assessed. Either it has to be broken down into several days, and here's the amount of time that needs to be between those days, or making recommendations for specifically how you can participate. But just because they've asked him to agree doesn't mean that he has to agree with you being able to participate in a functional assessment as they structure it.
Mm-hmm.
But it would be important, because keeping in mind that requirement to participate, it is important that it's not an outright no. You can just say, these are kind of the terms on which I can participate. I have a 1 hour energy envelope, and if I do it, then I need to have a 3-day break before the next one, and kind of setting the limits on how you can participate. And I see Dr. Arsenault popping up.
The other thing I usually recommend is to make sure that they book a visit with their family doctor or another physician within a week, so that they can
Yes,
good idea.
post-exertional malaise.
Yeah,
that is a great recommendation.
They don't capture that.
Yeah.
Mm-hmm.
Yeah.
Kind of like when I do an ICBC report, I build in a call 2 days later to say that having participated in my report has put the patient in bed for 2 days.
Absolutely.
Just to add a piece of information.
Yeah, that's really a good idea.
And that's a great recommendation. And it helps to emphasize, because it's usually not just one IME, there are usually more. It's helpful to emphasize exactly what your limits are. So, and if those are being recorded, that can be really, really helpful.
I think we also should mention that the LTD insurer can still cut you off. I mean, unfortunately, they have the power to do that. And even in the face of a medical report, they can still say, well, no, we say that you have to do this, and we say you're not participating, and so we're going to cut you off. So
the other bit of just practical advice I would give is, if they are using that report as a foundation for pushing you back to work, putting you into a rehabilitation program, et cetera, and you don't feel like those things are advisable, even if you do feel like they're advisable, get a copy of that report and have it looked at by your treating doctors. And I say that as somebody who personally did not have a copy and was told that I should be returning to work, and that returning to work full-time, I was working part-time. And then when I got a copy of the report, it did not support the return to work. So I think it's really, really important to have a copy of that and to have that looked at by your treating specialist. See what their recommendations are, whether they agree with it, whether they don't. If they don't, you can get something in response saying, this is why I don't agree with this, or this is why I don't agree with the limitations set out, or that I think they should be this, to help with structuring any kind of rehabilitation or return to work program that you're required to engage in. Questions around social media. What are your thoughts? My accounts are all set to private, but still worried that something could be misconstrued. This is a really important one. We see this with ICBC claims. We see these with LTD claims. I don't want to make anybody paranoid, but they do at times hire private investigators, and that can look like following you from place to place, watching your home or residence to see when you leave and how you leave and what you do. But oftentimes, and in this modern age, like I'm a bit older, so all of my accounts have always been private and I don't put a lot on them, but I think it's just very common for younger people to engage in social media in a way that kind of showcases their life. And sometimes things can totally be misconstrued. If you have social media accounts, keep them private. I wouldn't try to kind of spur any kind of paranoia, but I would say be conscious of the fact that if you say, I can't work at all, and then they find out you're playing softball every Tuesday and Thursday, that will present problems. So keeping in mind that it's very easy for somebody with unlocked social media accounts. It's really easy for somebody who's even minimally tech savvy to find your social media accounts and just scour through them, what you say, what photos you posted, etc. And just keeping in mind that anything can be misread. I had a client who I am very confident rarely leaves her home and was convinced once to go on an excursion on one day over a period of several years. And of course, ICBC tracked it down. So I think it's really, really important to be thinking about how you're presenting yourself online, and keeping in mind that anything can be misread. So private. I would say them trailing you is much less likely than there being a review of your social media accounts. I have only seen surveillance footage in probably, I don't know, 5-6 cases over more than a decade. And honestly, none of them were all that troubling. It was like, I don't know why my client took 20-30 minutes to pick out some flour, but she did. Or like the back of my client's head on a balcony for 3 hours and she's doing nothing. Like the hour, I honestly think that part of the reason those are produced to me is to kind of waste my time in pre-trial prep. I've not seen anything super damning in the surveillance video, and it is not common. So it can happen. It is not common. It is something that, but social media, far more likely.
Yeah. And the other thing is they'll also look at a spouse's social media.
Yes.
Or your children's social media. So hopefully that is all private as well, because they're pretty good about that nowadays. Yeah. They will really investigate that. Because it's
time.
Oh no, sorry guys.
Oh,
I'm sorry for any questions we couldn't get to.
Fantastic presentation. I've learned so much. And have a great week, everybody.
Thanks.
Thanks so
much.
much.
Bye, everyone.